Member for Abbotsford West.
Thank you, Mr. Speaker. The attorney gave a relatively long answer and managed to successfully avoid answering the question in any way, shape or form. My colleague, the member from Prince George, offered up yet again a specific course of action that this attorney and this government could take. And the attorney refuses to provide a clear answer, a straight answer, about why that step hasn't been taken. In fact, it's a recurring theme. The attorney, previous attorney, and the government continuously pleading a lack of ability to deal directly with chronic repeat offenders. But what we see, and what British Columbians see, is not a lack of ability, but a lack of will, Mr. Speaker. That's what they are seeing. You know, a few years ago, more than a few years ago, back in the 93, the then Attorney General saw a problem with domestic violence cases. And they were understandably and justifiably concerned. And then Attorney General Gableman took specific steps. He issued specific directions to prosecutors across British Columbia about how to conduct those prosecutions to address that dramatic rise in domestic violence, Mr. Speaker. Other Attorney Generals have issued similar directives in circumstances where it was appropriate to do so. 6 months ago in the course of the estimates debate, Mr. Speaker, I had this conversation with the attorney's predecessor, and I presented him with a draft directive. It's only one page. The significant paragraph reading as follows. In circumstances, it would be a directive to prosecutors. In circumstances when an adult prolific offender is brought before the courts on additional charges, a presumption shall exist on the part of the Crown Counsel that the public interest, including the safety of the public, is best served by seeking the detention of the accused adult prolific offender pending the disposition of the matter. That is a direction that this Attorney General could give. His predecessor did nothing, Mr. Speaker. I'll table it again after question period. But what I'd like to know, and what British Columbians would like to know from this Attorney General, is will he today issue that directive? And if not, why not?
Let him start, ma'am. Attorney General.
Well, thank you very much, Mr. Speaker. And as I said to the honourable member for Prince George Mackenzie, we are looking at the specific proposal that was made by the Lepard-Butler task force, if you will, in their recommendations, and that would be for a dedicated Crown Counsel. That is an area that's under active consideration. The member for Abbotsford West has, I think, made a constructive suggestion concerning the directive. We have, of course, reviewed it, and we've looked at this issue in the past and are continuing to do it. Mr. Speaker, the member will know the constraints that the courts have imposed when it comes to dealing with amendments to a directive changing the criminal law of Canada or changing the case authority, such as the Zora case. In other words, would the presumption that the member talked about be, would that line up with our criminal law and with the court's charter jurisprudence? Mr. Speaker, it was a serious question, and I'm trying to provide a serious answer. Yes, it's under consideration. Every tool in the toolkit is under serious investigation. But, Mr. Speaker, we cannot, with a directive, change the criminal law of Canada or the Charter of Rights of Canadians. And that, Mr. Speaker, is what we're examining actively.